was given one of the 7. So 6 are pending. And it took 2 days to do the one. So even by extrapolation, the minimum period the prosecution should be asking for is 14 days. Minimum 14 days. And if then, Your Honor, you could give us another 14 days to consider these documents, so that when we come for pre-trial, we are all prepared to proceed. So we don't adjourn again. We're asking, Your Honor, if the court is minded to ensure that we expedite this matter. We come back in 30 days for pre-trial, and that there shall be no adjournment on that day. I think that that's the way to go. So we come prepared for pre-trial. That would save time. Would give the prosecutor enough time, would also give us enough time to consider all the documents, so that when we come here, we'll take a very short time to conclude the trial. That's all.
I think Leonard Senior has spoken for us all.
Sorry, Your Honor, maybe to seek a bit of clarity, is there 1 month only in respect to 32 of 2019 or for all the 3 cases?
We're dealing with 32.
Yeah, just 32. We're dealing with 32. We are not in the other matters. We are only in 32. All of us are in 32. Then 31 as a number of counsel. So. Your Honor, in any event, the county is not there anymore. So there's no. It was taken over last night. That is coming.
It's not a done this way. Yes, it's not a done this way. Yeah, it's a big issue. Yeah, private arrangements. You can only hand over your assets in Maboka.
Can't remember.
What you've done, you can only transfer your own assets. It doesn't own the country. Yeah, it can't. None of it is a power. There's nothing. Kaplan and the people music to say like another thing. They're pushing it.
Now, we agreed that the prosecution stroke the investigative agency were to disclose by today. We agreed. I even engaged the IO in this matter. The information that I'm being given is that they have not disclosed. There is a question that I want answered, and I will make a ruling on this. I'll give the DPP the first chance to respond. And the question is, and please listen very carefully. Now, it's apparent that parties are held ransom after plea has been taken, and parties and the court is taken in circles. It's heading 3 months without due disclosure. Why can't the parties disclose? Here I meant the DPP disclose at the time of arrest, just before plea. In any case, investigations are complete by then. I know that there are no legal provisions dealing with specific timelines of disclosure. The Constitution only requires disclosure of a charge to accused with sufficient information to answer the charges under Article 50 of the Constitution, and also disclosure of evidence before the trial. I want this question answered because as I sit here, I feel the court is being held at ransom by failure to disclose. Mr. Kihara or Madam Nanjala. Then I will invite the defense to say something on that.
If we look at the record, it is our submission of Gavana Sonko, investigators and the DPP have actually done disclosure because all documents were provided, save for the inventory that was not, that the DPP has done full disclosure of all the documents that it intended to rely upon in this matter. What is pending before this court, Your Honor, is the amended inventory. That is supposed to conform to the directions of the court the directions that were last given in court on the 18th of February. And Your Honor, we do appreciate that it would be good practice to have full disclosure at the time of taking plea. And that is indeed where the system needs to move towards. However, in the absence of legal provisions, and the infrastructure in the various institutions, legal provisions, as the court has noted, and infrastructure that is required to support that kind of system in the institutions, it may take us a while to get to that ideal situation. And further, Your Honor, it is also our submission that disclosure can also happen in the course of trial, especially where investigations are still ongoing. There might be some new evidence that the investigators might come about, and the prosecution will have a duty to disclose that also to the defense counsel. But that said, Your Honor, we still maintain that the prosecution has fulfilled its duty to disclose, as none of the defense counsel have said that they do not have documents or any supporting evidence in relation to number 32 of 2019. It is only the inventory, an amended inventory, has come to court and said that they do not have documents, the necessary documents being relied upon in number 32 of 2019. What is pending, Your Honor, and that is the reason, Your Honor, why when we were doing the inventory yesterday, we started with volume 7, which were the documents that they were supposed to collect on the 24th of February 2020. These are the new documents that were yet to be supplied because they contained information relating to protected witnesses. Volume 7 was completed, Your Honor, albeit at 10 o'clock in the night, thereafter, thereabout. And the new documents, Your Honor, the other documents were collected. So in 32 of 2019, Your Honor, we submit that disclosure has been done. That is all, Your Honor.
Yes, Your Honor, I completely agree with this court that the court is being held ransom by the conduct of the prosecution. But apart from the court being held ransom, Your Honor, the first accused person and other accused persons are also being held ransom by this conduct. Of course, with very dire consequences to the rights of the accused persons. Your Honor, Article 47 of the Constitution is very clear on fair administrative action. And what the prosecution is doing flies completely against the principles of Article 47. Your Honor, my humble plea, therefore, is that the only way we can get the prosecution to move beyond holding both the court and the accused person's ransom is to take the drastic action of discharging the accused persons now. Then when the prosecution gets their house in order, the only way, Your Honor, to stop this issue of the prosecution holding the court ransom and the accused person's ransom is for this court to take the drastic action of discharging the accused persons now under Section 87A, so that at least they can go on with their lives and the prosecution can take as long as they want to arrange themselves. But as it is right now, unless that drastic action is taken, Your Honor, we will come back here after a month and we'll still be facing the same situation. Your Honor, I'm praying that you discharge under Section 87A.
Yes, you know, I've been asked to address you on two issues of the law, adding to what my colleague Miller has said. Yes, just on the law, just to help the court. It's an issue that the court has itself inquired. You know, I'll raise two issues under Article 50 of the Constitution. You know, Article 50 of the Constitution encapsulates the adversarial system in its whole totality, as enabled by statutes ensuing therefrom. The first one is that Article 50 presupposes that our trial, our legal system is notice-based. And the entire infrastructure under Article 50 is the accuser giving all documents and notices, and all those restricted to a period of time. You know, that period of time is regulated by court, so that both parties have audience before court. But more importantly, the court regulates the conduct of the accuser as against the accused.
Nam, ni wakili George Kithi hapo akizungumza. Wakili George Kithi akizungumza katika kesi hiyo ambapo gavana wa Nairobi Mike Sonko alikuwa anataka kesi hiyo ifutiliwe mbali kwa misingi kuwa uchunguzi haukuendeshwa kulingana na sheria, na hakimu hapo Douglas Ogoti amefutilia mbali ombi hilo, kumaanisha kuwa kesi hiyo itaendelea. Na hapa studioni niko naye wakili Elias Mutuma ambaye atakuwa